Work must be distributed in time, and we must make sure that we are the first people to interrogate the document before even legal comes in or before anything comes in. And they felt strongly that can we be given a blank page we don't want to be channeled. And there was also a concern that was raised that the people who crafted the material should perhaps refrain or not be part of this so that they are not defensive in whatever that they have produced. And there was a third concern again that there could be other people who are unable to express their views because my manager Soli is there listening, and Soli is saying we're going to the left, and if I dare say we're going to the right, there will be career limiting actions. I'm just reporting, don't kill the messenger. I'm just saying these are the things that came in that commission, the concerns. Colleagues, you will read, the reports are there. What we are doing at Commission 3, we are not going to look at the document. The document is a working document. It will be part and parcel of this report. So we're not going to go to that. We've decided to zoom into the issues. And starting with definitions. 1.1 there, we felt like the Commission 1, if I was listening there, we really feel that the minister there should be clarified as the cabinet member responsible for administration and implementation of this act, rather than the portfolio-specific reference. So there is some alignment there. Under definitions again, 1.2, the Commission reaffirmed that official languages must be consistent with Section 6.1 of the Constitution for avoidance of doubt, and to support implementation, the Commission proposes that the Act explicitly lists the official languages as Sepedi, Sesotho, Setswana, Siswati, Chivenda, Afrikaans, English, Xitsonga, isiNdebele, isiXhosa, isiZulu, and South African Sign Language, as they appear in that Constitution. And in 1.3 under definitions, the Commission further recommends replacing indigenous languages throughout this Act with previously marginalized official languages. Why is that? To reflect constitutional status and redress purpose. For the purposes of this Act, the Commission feels that previously marginalized official languages should mean those indigenous African languages that were legally and socially disadvantaged under apartheid and subsequently elevated to official status by the 1996 Constitution to advance linguistic equality, redress, and multilingualism, namely Sepedi, Sesotho, Setswana, Siswati, Chivenda, Xitsonga, isiNdebele, isiXhosa, isiZulu, and South African Sign Language. That is our input for Section 1 under definitions. And we move to Section 2, which deals with the objects of the Act. 2.1 specifically, the Commission proposes that the Objects Clause expressly provides for the regulation, monitoring, and enforcement of the use of official languages across all three spheres of government. 2.2, the Commission noted that the Act's effectiveness depends on clear consequences for non-compliance. The Commission recommends the provision be made for penalties or sanctions where there is failure to comply, and that legal services explore appropriate offense or penalty provisions, including those reflected in the Mpumalanga Language Act, to inform drafting options. We are not saying what was presented by Udantile the other time, it is the one, but we are quoting what we have. That is the only act, the Mpumalanga Act, that talks about sanctions, and it says, offenses and penalties, any person who contravenes or fails to comply with the provision of this Act is guilty of an offense and liable on conviction to a fine or imprisonment for a period not exceeding 24 months or to both such fine and imprisonment. So we are tasking legal to say, use that and come up with something that can be added as penalties in this particular Act. Further, in the very same section, the Commission further proposes that the objects include facilitating equitable, inclusive, and barrier-free access to government services and information in compatible formats and enabling meaningful participation in language-related processes. I think this was also mentioned by the previous Commission. We also recommend that we provide for mechanisms for regular, independent oversight, structured public participation in language policy development, and periodic review of the Act's effectiveness in advancing multilingualism and redress, including reporting to Parliament on progress towards equitable language use across all spheres of government. You will see this across all three spheres of government is recurring in this Commission. Section 3, application of the Act. The Commission recommends that the Act must apply to all three spheres of government to give full effect to the constitutional framework and ensure uniform implementation and accountability. We are mentioning this right from the beginning so that when these appear as we move, we have already dealt with them from the beginning. Language policy requirements, which is section 4, we propose 18 months there. For 4.2, in relation to section 4.2b, the Commission recorded two principal approaches regarding the minimum number of official languages. Colleagues, my commission here, I think we spent an hour debating this issue. And my commission had a lot of learned people there. Yeah. And some had dictatorial tendencies. I thought I had mine, but I'm weak. And some were even thanking me for extending the time, abusing me there. It's fine. But at the end of the day, we reached a consensus. Remember, we are here sharing views. We may agree, sometimes we may really disagree. So we reached a consensus to say, colleagues, we are not agreeing. There are two strong views and people are giving facts to us. So we resolved that there's approach A and approach B. Approach A, very strong idea that we must align strictly to the constitutional wording of the Constitution says at least 2. And if we go more than 2, we are against the Constitution. And whatever that will do will not work because at the end of the day, the Constitution says 2. That's a very strong view. So we said, we're putting it like that. There's a view that we should stick. The view also said the fact that even the UOLA in 2012 was saying 3 was against the Constitution, contradicting the Constitution which says at least 2. So we must at least for now align with the Constitution to avoid provisions that may be susceptible to constitutional challenge. But another view was saying, no, perhaps we need more than 2 official languages to advance additive multilingualism and reduce the risk of institutions limiting implementation to only 2 languages. So those are the views I think we will be guided. Moving right along on the other parts of that section, the Commission further clarified institutional terminology and resolved that all spheres of government should establish language units, and the unit located within department responsible for X should be designated as the National Language Unit. In the document, you will see that sometimes it's National Language Unit, sometimes it's National Language Service. But then the Commission resolved that, let's clear the confusion. The one that is at DSEC, let it be known as the National Language Unit. And for all these other departments, they'll have language units, just for clarity. And again, we identified potential overlaps of conflicts of interest regarding roles, responsibilities, and oversight functions between PENSALP and the department responsible for the administration of this Act. I think the other commission also identified this. The Commission therefore recommends that the respective mandates be clarified in the legislation and that legal services consider relevant constitutional jurisprudence, including the matter raised by Advocate Lawrence, when advising on appropriate oversight model. We move to Section 5. Institutional arrangements, national language unit and language units. 5.1, in considering the establishment of national language unit, the Commission again noted concerns regarding potential overlaps and conflicts of interest between PENSALB and the department. The Commission reiterates its recommendation that the oversight role be expressly clarified in the legislative framework informed by the applicable court guidance. On Section 6, functions of the National Language Unit, the Commission recorded that the monitoring and evaluation roles of the National Language Unit and PENSALB require clarification, particularly regarding delegated authority, reporting lines, and accountability for compliance monitoring. The other colleagues have said who does what, who reports to who. Section 7, establishment of language units, we reiterate all spheres of government. So we recommend that each institution establishes a language unit with appropriate capacity and independence. In particular, the Commission recommends that the language unit, the other commission was saying it should be appropriate. We are expressing ourselves that the language unit must be headed by a suitably qualified manager with relevant language-related qualifications and expertise, appointed in line with the appropriate public service or entity prescripts. And the position reports directly to executive management and is empowered to provide independent advice on language policy and all related matters. 7.2, we further recommend that every institution must, within 12 months of commencement of the Use of Official Languages Amendment Act or such period as may be prescribed, not exceeding 6 months, submit to the National Language Unit and PENSALB for comprehensive resource plan for its language unit. The resource plan should include, at minimum, the staffing structure, medium-term budget projections, performance indicators aligned to the objects of the Act and Section 6.2 of the Constitution, and implementation timeline that provides full operationalization of the language unit within a period not exceeding 24 months from the commencement of the Act. Section 8, functions of language units. Again, I said there will be a recurring theme. We really feel that national departments, national public entities, we say, can we just have consistency and say all three spheres of government to encompass everything? The Commission on 8.2 recommends that the respective mandates, functioning and reporting arrangements between National Language Unit and PENSALB be clearly delineated to avoid duplication and uncertainty in monitoring, evaluation, and enforcement. So at least this is recurring again and again in all these sections. And then the Commission further recommends that the drafting of applicable subclauses, including Clause 8J, expressly takes account of provincial legislatures, including MEC structures, and local government, including MMC structures, as relevant to ensure practicality across provinces and municipalities. On Section 9, the Commission again identified potential conflicts of interest and overlapping responsibilities between PENSALB and the department. This is regarding monitoring and evaluation. And then we further recommend that oversight responsibilities be unambiguously allocated in the Act and that the legal service consider relevant constitutional guidance. The annual report to the National Assembly. The Commission proposes that the responsible cabinet member must on an annual basis table a comprehensive report in the National Assembly on the status of the use of official languages across all three spheres of government. Maybe this commission should be known as Commission 3, all three spheres of government. On 11, intergovernmental forums and the use of official languages. The Commission recommends that the Intergovernmental Forum framework provides for adequate overall oversight where monitoring and evaluation arrangements are not sufficiently clear or effective. What do we mean? Provision is made for overall oversight where monitoring and evaluation arrangements are not clear. Potential conflicts of interest between PENSALP and the department are addressed through clear role allocation and oversight model informed by the Constitutional Court guidance. Forums are convened by a designated coordinating structure operating under approved terms of reference to avoid assigning operational coordination functions to the cabinet member. Exemptions, application of Section 7. A comment from the Commission is that we recommend that where an exemption is granted, because we were told that the people, if they don't have the resources, if they are not ready to implement, but we said surely if an exemption is granted, the responsible cabinet member must explicitly stipulate the duration of the exemption. You can't be exempted forever and ever. In every financial year, you are exempted. There must be a duration guided by the qualitative and quantitative variables set out in the application submitted by the requesting entity. That brings us to the end of the inputs by Commission 3 called All Three Spheres of Government. Thank you, Chair.
It looks like we are on time and we are making good progress. And I'm now calling upon Commission 4 to come up on stage so that we can conclude in terms of the reports.
Good morning, colleagues. My name is Chloe Machekana. I'm standing here on behalf of Commission 4. The nice thing about being the last commission, I can just say, ke la ka leo. Program Director, please allow me not to take the plenary through all that we captured per section, but to confirm that Commission 4 went through each and every section, following the prescripts by your legal team, where we made our own proposed amendments together with the comments as we were requested. And also, please allow me to mention that the previous 3 commissions really covered us in terms of the technicalities that we picked, grammatical errors that we corrected. So I'm not going to bore the meeting with repeating all that was said. I'm just going to now dive straight into the presentation. Okay. As I've already mentioned, colleagues, for the purpose of this presentation, this commission will only focus on key areas that we identified that we feel that should be considered for the amendment of the bill. As I've already mentioned, that we managed to complete the template, and we will then submit to DSAC for consideration. So, as I've mentioned, colleagues, Commission 4, sorry about that. Commission 4 identified about 11 key areas. This is what we are just going to highlight in this presentation. But the template that we used to fill in and to review has got each and every aspect that we want the task team to consider when dealing with the amendments. So in section 1, we realized that the insertion or the original version had language matters, which the proposed one suggested a deletion. We, as the Commission, we feel that to emphasize the relevance and the importance of languages, and I think this is one thing that brought us here, because we feel like we are not heard, we are not taken seriously by government because we are not prioritized. So if we move language matters from their definition, then we are subjecting ourselves to being secondary, where else we feel the need that we should also be amongst the key priorities of government. And I think it was Commission 1 where they spoke about South African Sign Language. We also support that South African Sign Language is one of the official languages. Therefore, it should not come after the others. So when we speak about official languages, that includes South African Sign Language and should be treated equally so. And I think this came across the previous 3 commissions regarding the use of phrases such as reasonably practicable, encourages, voluntary adoption, if willing. So we feel that they can be interpreted as escape clauses, and I think we can all agree that this is one of the reasons majority of our public institutions do not comply. So to enforce compliance, we would like to recommend that the bill removes such phrases and ensure that everyone is complying with the Act. As we continue with the key areas that we identified, in section 2E, where it speaks about public participation, we felt the need to include the word meaningful, so that we don't just tick boxes, so that we don't just create policies, we gazette, and we think that's it, we have covered the public. But let's take our policies to our people. They are about them. So we need to avoid the top-down approach, and we become a government that listens to its people and take their needs into consideration. It will not serve any purpose for us to gather here yearly review when we are not incorporating what our people really need. Hey, I'm sounding like a politician now. Section 3, application of the amendment bill. Commission 3, you were not the only one where you repeated all 3 spheres of government the entire session. Yes, because we feel the need that the Act should not only apply at national level, but it should also go down to provincial and local government. That's where service delivery actually takes place. And we need to give our people access as the Constitution is guiding us. And even this one, I won't dwell much on it about the functions. I think the previous commissions did very well in terms of ensuring that the Act really clarified the roles and responsibilities of the minister and PANSAP. And we would also like to advise the task team to actually, when they deal with this, they put the Constitution right next to them. It will really provide proper guidance as to whose power belongs to who. Section 5 to 7. establishment of language units. We are of the view that all 3 spheres of government should have language units, and these units should be headed by, actually these units should be capacitated with qualified language practitioners who hold relevant academic and professional qualifications. Each language unit must be headed by a suitably qualified language practitioner at a senior position, and we recommend senior position not being a deputy director or a director, at least chief director. Or maybe a level that allows decision making, because I think some of us can agree that we've been presenting what our units are doing or what they are planning to do, but we don't get really feedback. But if the unit can be headed by a decision making senior position, maybe we will get somewhere. Section 12. I think this is one thing that this commission does not agree with the previous ones. We are saying section 12 should be deleted. No exemption should be considered. If you are there to serve the public, you need to ensure that the public has access to your services, including in languages they understand. I don't know how the task team will go about it, but we also feel that these exemptions are actually weakening the purpose why we are here. It allows national or even provincial or any public institution a door to escape from complying. If we are saying that some of the conditions include budget, we are all complaining about budget cuts, but the Constitution still allows us to ensure the use of all official languages. And I don't know if I skipped it somewhere, but in terms of the adoption of languages, we saw others are recommending 7, others 3, 5. We are saying national departments should adopt all official languages, and provincial local government, it will depend on their geographical areas. For example, when you go to Limpopo, we expect Xitsonga, Tshivenda, Sepedi to form part of their identified languages that they should ensure they have in their language policies. To conclude, all that we've presented, it's a position grounded in the principle of uniform compliance across all spheres of government, which is essential for ensuring consistency, accountability, and effective service delivery. Exemptions would undermine the objectives of the Act, create disparities in implementation, and weaken the overall impact of the legislative framework. I think I've mentioned some of the things here. Therefore, thank you.
Thank you to Commission 4. I think we should all give a round of applause to all the Commission's colleagues. What is more encouraging about their presentations, colleagues, they have sort of put forward a lot of things that we need to consider moving forward in terms of the finalization of the processes that will follow after this consultation. Colleagues, we were expected to break for tea in maybe 30 minutes time. And since I've been very strict on the time that was given for the commissions to present, it gives us ample time, colleagues, to break for tea, stretch our legs, and I would be more than happy, colleagues, if we can start with the Q&A sessions exactly at 11 o'clock. My time now, it's 26 past 10, meaning that we have more than 30 minutes. 11 o'clock, I'll be ascending the stage, and then we'll start. Thank you very much. presentations from the chairpersons. And my request, colleagues, is that we do that very briefly, starting with the first, the second, the third, and the fourth commission. If there are no additions, colleagues, that we would like to make in terms of what was presented to us, there's no need to waste time. We'll directly zoom into the questions and answers, and we move on like that. Starting with Commission 1, maybe you can show by raising your hands if there's anything that you would like to add to the presentation. Commission 1. There are roving mics, colleagues. The moment when you raise your hand, you will be recognized and the colleagues will assist in making sure that you get a mic so that you can raise whatever you want to raise. Are we sorted for Commission 1? Can we move to Commission 2? Commission 2? Oh, Commission 1. Okay. You are recognized. You can go ahead.
Thank you, Chair. A very good morning to everyone in the House. Maybe just to explain quickly our approach when we actually dealt with the document. Maybe to actually place some emphasis as well, the approach that we undertook when our chairperson mentioned that we actually looked at different kinds of instruments before we looked at the instrument at hand. Firstly, when you initiate any amendment, you initiate an amendment to an instrument only where there's a mischief. We're not actually privy to the mischief. What was the rationale to trigger the amendment? So we actually approached the draft on assumption. We looked at the Constitution because of Section 2 of the Constitution. Any law or conduct that is inconsistent with the Constitution is invalidated. We looked at Section 6 of the Constitution because Section 6, in fact, EOLA is an extension of Section 6. We looked at Lawrence, what Lawrence is saying. Lawrence is challenging Section 4 of EOLA on at least 3 official languages, where the court said, SCA, Constitution is supreme. Constitution is supreme, so the provision that actually speaks to at least 2 official languages should extend. We actually took that and actually juxtaposed it with the proposal of 7. And yet it was ruled already on 3. So our question was, in the existence of this constitutional contradiction, is this piece of legislation or bill enforceable? We're questioning now the validity of this instrument. And also with the overlap between the ministry or minister and PANSLAB, we need to actually focus on Section 85 and 91 of the Constitution with regard to the appointment of cabinet members. The President appoints cabinet members, and the members are expected to coordinate the affairs of their respective portfolios. And they are expected to report to Parliament on their departmental affairs. So now, if we're going to replace the minister with PANSLAB, we need to take cognizance of that provision in the Constitution. And also, we could not see the role of the DG as an accounting officer. Because if government departments are expected to report to PANSLAB, and PANSLAB will actually take initiatives where there's failure or non-compliance, that should be the role of the DG. One accounting officer speaking to another accounting officer. So when it comes to representations at FOSAT is a forum for South African DGs. How PANSLAB is going to report at that platform when there's a DG already in the department? And with regard to in consultation with, and the use of the word must means mandatory, may means discretionary. So if we're saying the minister must, in consultation with PANSLAB, In consultation means legally, there's a case law pertaining to that. There must be concurrence and consensus before the minister could do anything. In the absence of that concurrence or consensus, what's going to happen? If the minister chooses not to consult with PanSlab, what's going to happen? What will the reprimand or sanction? And the minister is also responsible for PanSlab Act. An institution now is saying, minister, report to us.
Okay, sir,
Legally, in terms of logistics.
can I stop you there?
Thank you.
Because it feels like to me you are now dwelling into where we are heading to. But your point is taken. Thank you very much for that addition. Can we move to Commission 2? I see a hand over that side. Like I indicated, let's try to be brief, colleagues.
In terms of Section 12, where we spoke of exemption of applications, I know there's a commission that said that should be scrapped out. Our agreement as a commission was that we should have a minimum years, minimum and maximum years of being exempted. Also, it should not be renewable. You cannot renew, and in this case, we will also like that PanSlab be directly involved in monitoring. For example, on a quarterly basis, whoever is exempted should actually report on progress that they are making in order to establish a language unit. Thank you.
Thank you, Commission 2. Moving on to Commission 3. Any addition from Commission 3? I don't see a hand. Oh, there's a hand at the back. Yes, you are recognized. Prof.
Thank you,
can go
Chairperson.
ahead.
Morning, colleagues. I think the only addition is actually on language policy 4B that deals with the number of languages that should be selected. So obviously, our chairperson did indicate that there were two ideologies that were postulated. So when it comes to two, we did indicate that it is important to emphasize that one of those two languages should be one of the previously marginalized official languages, because that is a gray area. Because if we don't emphasize that, one department will come and choose both English and Afrikaans, and in terms of the Act, in terms of the Constitution, they would have complied with the Act itself. So if the final decision will be on 3 languages, the same principle should apply. We should be able to indicate that 2 of those languages should be part of those languages that were previously marginalized. Thank you.
Thank you, Commission 3. I see there's another hand. I think it's still on Commission 3. You can go ahead. Thank you.
Yeah, thank you. What I just need to briefly state is the obligation we have in law when we do this kind of work is that our country's jurisprudence is premised on transformative constitutional democracy, not just democracy. Transformative constitutional democracy. So whatever we do has got to show transformation, not establishment of the same humdrum. That's number one. Where do we derive that? We derive that from Section 1.1 of the Constitution that says this is a democratic country founded on the following democratic values. 1, human dignity. And it does not say human dignity, equality. It says human dignity, achievement of equality. There's a verb there. So whatever we propose in this amendment, if it's not towards achieving equality, then we are not performing in terms of the spirit of the Constitution. And it says advancement, there's a verb there, of human rights and freedoms. There's an S there. It's not human rights and freedom. It's freedoms. So, if we debate anything when the debates start now, we must know that it is fundamentally about that. And I know we will raise issues of the quota, whether how many people speak this language and da-da-da-da-da. Fundamental human rights is enshrined in our Constitution, as I conclude. In the case of the Harris case, where one child of 5 years, approached the Constitutional Court and raised the matter that me alone, I'm ready to go to school. The act said 6 turning 7. She says, I'm 5. I'm ready. The court ruled in favor of the child because that right did not need a group. It's an individual right. Now, when we deal with these matters, and we had to change South African Schools Act and accommodate that child, we changed it in 2001. Now, when we deal with these matters, as we round up, we must know that no one's rights must be violated simply because he or she is a minority. Thanks.
Thank you. Commission 4. There's a hand for Commission 4. Yes, you can go ahead, ma'am.
Thanks, Chair. My name is Rufuno Neshitomboni. I must say our commission did so well, and our presenter did very well. She's a product of arts and culture and states essay, so I must say so. I just want to make a point. We did talk about it, but because she summarized, I'm sure it's on the report, on the matter of language unit. Usually, I think most of the commission mentioned the need to know what are the function, what is the language unit, and all that. I'm old, so the language unit, that document that was developed at Arts and Culture, it's there, but I think there's a lot that needs to be revised in that. If I was there, I think maybe around 2003, 2004, you can tell that there's a lot that we need to revise, and I'm sure a lot of people are not aware of that document. And that is a document that should actually, together with the Act, circulated to all the national departments, or all 3 spheres of government. Because how do you establish something that you don't know what it's supposed to function? How is the structure? Hence, they just lump us with communication. In most cases, we don't know. We are not defining that. So that is the part that I think from the National Language Services, that needs to be revised so that we can move from the same page. The second one is the role of PenSALB. And I think ever since I started working in the language field, I've been hearing about these conflicting roles of DSAC and PenSALB. But I do not think there should be. The Constitution is very clear. Just in Chapter 1 of the Constitution, of the founding principles, PenSALB is mentioned, and its role is clarified. And we talk about the functions, and we don't have teeth. And I would tell you that we are breaking our own teeth as PenSALB. Go to the Constitution, Schedule 6, Section 21. It will tell you of constitutional institutions. And this is the the list of those constitutional institutions that are there: the Public Protector, the South African Human Rights Commission. I'm reading so that we understand what I'm talking about. The Commission on Gender Equality, the Auditor General, the South African Reserve Bank, the Financial and Fiscal Commission, the Justice Service Commission, or the PEN South African Language Board. So if you put them in that category, and you understand that the Auditor General, they will monitor how people are implementing the PFMA. Why is PENSAP not doing the same? Because it's there in that same category. They must audit language implementation, multilingualism implementation, and they have the power. It's in the Constitution. How they implement that, it's another thing. There's no way we don't have teeth as PENSAP. We have teeth. Why are we breaking them?
Okay, thank you. I don't see any further hands, colleagues, in terms of the additions coming from the 4 commissions. And now we are heading into the crux of us having gathered here, colleagues, for the past 2 days, where we need to move into the questions and answers. Let me try, colleagues, to guide the process. It will be very fair for me as an individual that if I propose something, I should also at the same time come up with a possible solution to what I'm proposing, so that it guides us as we move along, colleagues. Otherwise, I cannot question something that I myself, I don't have any possible solution to. Pose your questions, and at the same time, try to lead us towards what you think it will make us achieving what you are proposing. I think if we follow that trend, colleagues, it will take us to another level. Because when we are done here today, there's still a task team, colleagues, that is going to go through all the proposed amendments and additions and try to work through the documents, sift through the information before it's taken to another level where maybe it will have to be taken to clusters and stuff like that. So let's be very clear, and I'm happy with the additions that were made so far because they were sort of giving us some direction as to where we should go in moving towards concluding our session for today. This is my introduction, colleagues, in terms of how we should proceed. And what I would like us to see, colleagues, we'll have one round of questions, maybe 1, 2, 3, up to 5. And then we debate or discuss on that, we conclude. And then there will be another round of questions or proposals. And we move along that way, colleagues, so that we don't find ourselves moving back and forth, back and forth. So the stage is open, colleagues, for questions and answers. I've recognized a hand up front from Dr. Machava as number 1. Can I see if there are any further hands, colleagues, so that before she takes, there's a hand from Dr. Halane. You are noted as number 2. Ms. Nechitomboni, thank you. It's number 3. Any further hands for this round, colleagues? Okay, let's take these first 3 colleagues in that order, starting with Dr. Machava, Dr. Halane, and Ms. Nechitomboni. Thank you. Over to you, Dr. Machava.
Thank you. Thank you.
Thank you, Program Director. Good morning, colleagues. Mr. Ntlakane, I fully heard, understood, and fully agree with your group's restraining order. But you know, in fora like this one cannot resist the appetite to learn. So please allow me to ask a question for the mere purpose of learning. I noticed that Group 1 and Group 3 have proposed that the definition for minister be replaced, that part of minister be replaced by a cabinet member. And in my understanding, cabinet comprises the president, the deputy president, and the appointed ministers. And a minister heads a portfolio, a particular portfolio or department. The proposal to shift from the specific definition to the general one, maybe just to make us understand there and clarify the rationale. Thank you very much.
Thank you. The question is noted. Dr. Khalani.
Thank you very much. Just two brief ones. We've got National Directorate of Public Prosecution that deals with its matters there. For us to call this a unit, are we not minimizing the role it's supposed to play? Why don't we just change the name? We have an opportunity here. It's an amendment process. And maybe we call it National Directorate on Language. That's my proposal. Number two, instead of struggling with how many languages and so on, can't we rather be more businesslike and say for each government department, a given percentage of its policies needs to be translated into all official languages per annum? Then you don't deal with. When I raise the question that one child and the fundamental human rights of that one child of 5 years changed a law of general application for all learners in the country. So you can't now begin to violate what Section 1.1 says, achievement of equality. 1.1 already lifts 9, Section 9 of the Constitution on Equality. So you can't postpone anybody's right, linguistic right, to later when we have money. We're already 33 years since 1993 interim constitution. We still have not realized the rights of linguistic rights of South Africans. So if we go the path of 2, 3, it's not going to work. At DBE, we come from a process that we worked with PENSALP, where we took maths, we took science for grade 4, and we translated the policy into all official languages. We're now moving, we've just adopted a 3-year plan to move along that line and do for all subjects at the same time over a period of 3 to 4 years. But you cannot have a situation where somebody's linguistic right is left behind because there was a vote that we do 2 languages or 3 languages. So the fundamental human rights are not based on numbers. You are born God-given rights. That is why the Constitution says achievement of equality. And when you show process, obviously the courts normally understand when you show process towards the achievement of the right or realization of the right. And that's why when it goes on, the same provision 1.1 says, advancement. To what extent are you showing evidence of having started dealing with the mechanics, and you are, at least at this point, you have not achieved it, but you are advancing it. So the Constitution balanced process and product. So that we take the view of a percentage of policies by each government department that needs to have been versioned to all 12 official languages per annum in a manner that is achievable. We have done 2 subjects, 2 policies in 1 year. So it can be done. Because at the end of the day, what is the purpose of this act, Chairperson, is that at the end, all policies of all governments must be available in all official languages. But if you're going to focus on the number and forget what the outcome should be, the outcome should be all policies versioned in all official. But you can't do it overnight. You've got to have over a period. If the act says in 5 years, all policies need, because this is a governance mechanism. We're not talking about language as a beautiful science of artistic expression. We're talking about language as it expresses policy. Thank you.
Thank you, Ms. Nechitomboni. Over to you.
Thank you. For me, it's just a point on the 3 spheres of government. Since here, the focus was on national departments and public enterprises, I would like to ask that consultation be extended to the provinces then also, and municipalities, because here, if I can check properly, it's national government. So if this point that we have suggested from different commissions is taken, I think then we need to be fair and not talk about provinces and municipalities without them being consulted. And then the second one is just on the act. I think PENSAB is mentioned, and it makes sense because even from the act, from the Constitution, they've been mentioned. However, I seem to understand from all commissions the issue of professionalizing, or saying that people who should head the language units should be professionals. I think then the South African Language Practitioners Council should also be one of the key institutions that are meant to implement this act, because then the professionalization of language practitioners would not be an issue, because that council would, the act and the council would also address that matter. Also, taking into consideration the presentation that was made by the DDG of Basic Education on the first day, I can tell, and I think all of us can agree, that the Department of Education, be it higher education, basic, are very critical in the implementation of language and implementation, because that's where they are taught, and it's a formal acquisition of these languages. So I was just, it's a question, it's a suggestion to say in the act, maybe the key stakeholders that are meant for the implementation of the act should be, mentioned, just like PENSAB, their role is mentioned clearly. But education, remember also the right to receive education in the language you understand is also there. So I think then by virtue of them giving that right, or being mandated to ensure that right is implemented, they should be mentioned as a key stakeholder, just taken out of that, because I know Stats SA is mentioned in the regulation as the key stakeholder to ensure that they those who develop policies, they look at the statistics that is produced by Stats SA. So I'm just saying, I think those are the key stakeholders that should be mentioned. Thank you.
Thank you. We are now getting into a point where we are getting responses. The first part, colleagues, that needed further clarity, it was directed to Commission 1 and 3. And it's in terms of the definition of the minister, moving away from the current definition to what was proposed by the two commissions. And I'm not going to limit the responses to the chairpersons of the commissions. I will open it up to everyone in the room so that colleagues, if there's anyone, colleagues, who would like to give more clarity into that, we are all welcome to do it, colleagues, because we are together in this. I don't know, Mr. Ntlakana, if you would like maybe to take a bite before the rest can come.
Can I respond on behalf of Commission 1?
Okay.
It's the cabinet member responsible for is a drafting preference. We evolve in the legislative drafting, so there's nothing beyond that. Because the newer legislations or bills are actually drafted in that fashion. So there's nothing wrong with as being the minister responsible for. But because of we evolve in legislative drafting, it's a cabinet member responsible for. Thanks.
Okay. Can we get a mic to Mr. Ntlakana? Just behind you, Sis Corey.
Thank you, Chair and colleagues. And I think this is the last time that I'm speaking. All these questions must also be directed to members of Commission 3.
Okay.
Because I'm not their spokesperson nor their advocate. I was just a chairperson there.
Thank you.
But getting directly, in contrary with Commission 1, which seems to have had legal experts, in my commission, we really wanted the issue of consistency to say there are times when this minister previously is the Minister of Arts and Culture. And then it changes again to be the Minister of Sport, Arts and Culture. Perhaps in future it will be Sports, Arts and Culture and Recreation. Maybe it will be Sports, Arts and Culture, Recreation and Education. And we felt not on a legalistic matter, but we felt this should be a minister responsible, the cabinet, like the other colleagues said. Just for us not to keep going back again and have to amend and say now it's no longer arts and culture, it's now sports, arts and culture, blah, 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 going forward. But members of Commission 3 spheres of government, if I am misleading, please come in and correct me and keep me honest. Thank you, Chair.
Okay, thank you.
Yeah, just a small addition in the definition principle. We can't use the word minister to define a minister. So a minister cannot mean a minister of 1, 2, 3. So a minister means a cabinet member responsible for 1, 2, 3.
That's the proposal, colleagues, and clarification. Commission 1. So you are sorted. Okay, thank you. It looks like both commissions' colleagues are in agreement that that's how they propose it should be reflected. And for the purposes of moving forward, colleagues, we are moving on to the next one. I think the point that was raised by Dr. Khalani in terms of us not cracking our heads with the numbers of whether to say 2, 3, or 7, he's coming up with a very good proposals, colleagues, that maybe instead of us focusing on the number of languages, we should sort of maybe dictate or decide that at least a certain percentage of policies for all our government departments are translated into all official languages. Per annum, we set ourselves such a target that if Department A has got so many policies, maybe we cap it at 20 or 10%, depending on what will be the final outcome of this. Maybe that will be the way to go, because when we look at the issue of numbers, it's taking us to a point where I think colleagues did mention it, that it's in contravention with what it's in the Constitution. So maybe colleagues, okay, let me also raise the second point from Dr. Khalani. It was about the unit, us restricting ourselves to a language unit, maybe moving towards saying it's a national directorate that is responsible for languages. It's a proposal, colleagues, that is putting on the table that we need to think about and consider. And colleagues, I'm opening it up now. If there's any additions, colleagues, that you would like to make regarding what was raised by Dr. Khalani, if in terms of questions or further input. I think it was very clear, colleagues, what he was proposing and putting forward to us. One, yes, Ms. Kulek.
I think I agree with Doc, because you will find a situation, if we limit it to a certain number, you will then find a situation where one language within the African languages is always on top, and the languages that have minimal speakers will always not be considered as part of the language policy of that department. In this example, I will cite the Nguni languages, which is isiZulu nesiXhosa. They are always in the forefront. And then when you go to Xitsonga and Tshivenda and isiNdebele and Swati, because of the minimal speakers that they have, they are not really considered as translatable. So it's like the number for translation is very less, because there are less of those speakers. So what Doc is saying, we will avoid a situation where other African languages are way ahead of the others. We will then start to be on par as African languages.
Okay, thank you. While you were still on that, colleagues, I was reminded, I think it was Commission 3, if I'm not mistaken, when they were reporting. They proposed two approaches. A, which is, they were saying that we stick to what is in the Constitution currently, where the Constitution is saying 2 languages. If we advocate, maybe we want to come up with another approach, that approach should at least accommodate one of the previously marginalized languages. I think if I recall very well, it was an addition that came from Professor Rahuhu. Maybe let's try to, I want us to spend some time on this one, so that colleagues, we move together. I see there's a hand from Mr. Nemutamvuni. Sis Corey, if you don't mind, you can pass the mic, and let's hear Mr. Nemutamvuni's view. Over to you, sir.
Okay, thank you, Chair, for the opportunity to speak. Yeah, in our commission, so we had a serious challenge and disagreement with regard to the issue of numbers of languages. So we asked ourselves, a question like, what does at least mean? So in my layperson understanding, it means that not less than 2. So which means that, any public entity or any department, can use all official languages if that department has got budget or it has got money. And definitely the principle of rotating the languages according to groupings, Nguni, Sotho, so on and so on, will apply. So I don't think that the Constitution is saying the languages must be 2. So to say 3 or 7, I don't think that, according to my understanding, I don't think it's unconstitutional because it's just open-ended. If we have got 100 official languages in the country, we can use all of them. We can say 100 languages in this act that we are amending. Currently, it's mentioning at least 3 languages. And I believe that this act took that UOLA to Oxla, and Oxla vetted it and certified it that is constitutional. So I think it can only be unconstitutional if we are saying at least 1, because that is less than 2. So going up, you can go to 1,000 if you want, because the Constitution is saying, it's saying at least, which means not less than.
Okay.
Thank you.
Point taken, Mr. Lemtambuli. There's a hand at the back. You are recognized, and also a hand up front. I'll start with Paul. Oh, yeah. You can go ahead.
All right. No, thank you very much. I think one of the things that we need to also take into consideration is that when we work on the act, we must also put in mind implementation and monitoring and evaluation as well. And I hear my colleague there saying that we can say at least 7. We are still protected because the Constitution has said at least 2. But what was argued was that the act must bind, must have teeth. So that means that if people are going to not to comply, there was a recommendation from our commission to say there should be an imprisonment of up to 24 months or a fine. So if that is going to be the case, then you would need to prove that this particular entity or national government department has not complied. Now your act would be saying at least 7. So if your act is saying at least 7 and a person has done 3, they have not complied with the act, because your act is saying at least 7. So they've contravened against the act. Now there have to be those punishment and penalties. But now when you go to the Constitution, the Constitution is now saying at least 2. Now, which law is supreme? Is the Constitution. Because you cannot argue to say, because the Constitution is saying at least 2, then you can go up to 1,000. Because when you are going to be litigated, and it's even taken up to the Constitutional Court, because you are saying that this person has not complied, the Constitutional Court is going to rely on the Constitution. And what are they going to find in the Constitution? At least 2. Not the 7 that you have in your act. At least 2. We are arguing that there's no budget and stuff. Now, if we are going to push at least 7, we must also now make sure that there's budget for litigation, because that's where it's going to go. Thank you very much.
Thank you, Prof. Letsoalo.
Thank you very much, Chair. Yeah, I mean, inclined to what Professor Letsoalo indicated, to say that the Constitution is the supreme law of the country. We have just witnessed with what happened with the Palapala situation, when emotions take over. And so we we need to stick with what is in the Constitution. It says at least minimum. Now, at least, to simply put it, means on record, the minimum must be 2. But that is not just put blindly. It was put in consideration of certain circumstances. That 2 is chosen based on the demographics or demographic data of the population where the languages are used. It is not to say which one supersedes another. It is, do they apply in that context, yes or no? So if we take into consideration those things, and it was even mentioned that quite often institutions that have to implement these changes, they deviate from even status results, or data at least. And so they thumbsuck and they introduce languages based on emotions. It shouldn't be. It should be guided by the population within which these languages are found. And so the Constitution first, so that we don't have to account at a later stage. And at least means start with 2, then you can go on with other languages based on, obviously, practicality and the feasible conditions for implementation, as well as Prof. Letsoalo has indicated. So in support of the Constitution, and anything beyond that should be put aside for now.
Okay. Ms. Nechtomboni.
I was like my twin, I thought I wouldn't talk, but this is a matter that is very important. I kind of understand the principle that was used in the Constitution to say at least 2, but now when we say at least 3, I think that that is better. I'll tell you why I think I understand. However, if we are to go with the 7, think about if we are saying, we're talking about the 3 spheres of government. The national is almost broad, right? It's serving the whole country, that national department. So it will be very difficult to select which languages, which official languages should be used. The whole public must access that service, right? So I think there should be categories that talks about national departments, that talks about provinces, where now you talk about the linguistic distribution in that province, because if it's a province with 3 main languages and you say 7, now you are creating a problem, because the demographics there is not really speaking to that 7. But now when you go to municipality, they must also align themselves with the provincial languages because they are within the specific province. So I think those 3 spheres of government, if we indicate how each level can implement, like for State SA, it's very difficult to choose one. We collect data from everyone. So even the question is that we have to try and make sure they are available in all official languages. Who do we select? Who do we say no to? The Constitution says there are 12 official languages. Then when we go to provincial offices at State SA, then at KZN, they must now look at those languages that are relevant to that province. If they go now to City of Tshwane must speak in line with Gauteng. You understand? City of Joburg will speak to their region and all that. So I think if we can really categorize those, we will guide better. Because if we just have a blanket statement, it seems as if it will apply to all spheres of government, and they are not the same. Yeah, that's my contribution. I hope that's the last time. Thank you.
Yeah, and I wanted to, okay, you still want to add on that one, Menswaki? Over to you. Yeah. It's Mr. Tabachai. Over to you, sir.
It's Selotang.
Oh, Silo.
Yeah, Selotang.
Thank you.
Yes, from Social Development. Yeah.
My apologies for that.
You're welcome, Chair. I would like to align myself with what my previous colleague, speaker, was saying. In our commission, we intentionally aligned ourselves with the Constitution. For the reason that, Chair, we don't want to move too much away from the Constitution, because this is the supreme law of the country. And whatever we are going to suggest that is inconsistent with the Constitution, it can take us another 30 years for this act to be approved. That was the premise that we moved from. The other premise that convinced us to stick to the Constitution was that the YOLA of 2012, it was consistent with the Constitution, but then they went further to say 3 languages for the fact that and it was in contravention with the then Constitution. That's why we are now having this consultation on YOLA. Now, our take was that we want to implement this act, as in like yesterday. Once we move too much away from the Constitution, it's going to take a long time for us for it to be approved and to be considered as a legislative document. Because it's not just a document that we are creating on our own and we can implement it as and when we want to implement it. It's something that has to be approved even by the Court of Laws, because now it has issues of sanctions and issues of compliance. Now, we bear in mind that by the virtue of the Constitution saying at least 2, at least it says you can go to 20 to 100, depending on your constituency that you are serving, depending on the people that you are going to serve, to provide service, communication service to. It doesn't limit you in any way. And as we say this YOLA, we say at least 2, let's not go to 7 or 3, at least 2. It means when you are a department like we're doing today, in my department, we always make sure that we translate whatever we produce in English in the languages of the province that where we're going or the constituency that you are going to address. I hope that you are following, Chair. Now, it doesn't mean that we are going to limit ourselves to 2. When, as a national department, now I'm not talking about as a province, as national department, when we produce materials for our beneficiaries, we always make sure that when you go to Limpopo, we will then have English and Sepedi, and we produce that in that fashion. The same material, same information, we'll then also have it for the Northwest in English and Setswana. It doesn't limit you at all. But then for the sake of this specific legislative document to be approved the quickest way as much as we want it to be, we don't want to limit us to 1. We say we still stick to 2 as per the Constitution, but then any other body can go beyond that depending on their constituents. And I hope maybe colleagues will concur with me on this one, just for the sake of movement. Thank you, Chair. Thank you.
Okay, thank you, Mr. Tang. Colleagues, I want us to move towards the points that were raised by Ms. Nechtomboni, because I'm trying to link it with what Mr. Tang just said now, the 3 spheres of government. Because I think when Mr. Nechtomboni was given an opportunity to say something at the beginning of this round, she proposed that we should consider sort of extending this type of consultation to the other 2 spheres of government. If I understood her well, the proposal was that we are here maybe as national. How about if we can consider also consulting further with the other 2 spheres of government? And I would like us to spend some time on that one and make sure that at least we also cover it. It's a proposal that it's going to be debated and taken further. And the second part, colleagues, raised by Ms. Nechtomboni, it was on the question of key stakeholders. In summary, what she was saying, colleagues, was that the DBE, Department of Basic Education, and the Department of Higher Education, they are key to the implementation of this act. Therefore, we should also consider maybe having something that sort of talks about that in terms of our key stakeholders in the act. I'm not an expert in this field, and what is important, colleagues, we are putting our heads together, looking at the issues that are brought forward, and maybe debating them further. I can see already there's a hand at the back, already 2 hands. Yeah, it's 2, already 3. Yeah, I'll start with Prof. Letsoalo, Prof. Rahuhu, and I'm not sure it's Dr. or Prof. Mr. Tokwane, thank you. So in that order, starting at the back with Prof. Letsoalo, Prof. Rahuhu, then Mr. Tokwane.
Thank you, Chair. I wanted to check for procedure's sake. There was a matter on the table, Chair, that was being discussed, and we did not resolve on that matter. And I hear that now we might move to discuss other things.
Okay.
So I just wanted to check if it was intentional. We are going to come back to that point that we were deliberating on, or what? Thank you, Chair.
All right. Maybe on that one, I was trying to link the 3 spheres of government to the number of, vis-a-vis the number of languages. So to say that maybe the way I see it, the proposal was that the consensus should be something like, Prof, we stick to the 2. But in terms of the actual, it will be dictated by the circumstances and the nature of maybe, let's say maybe we are venturing into the second sphere of government, which is the provincial sphere. Then when you are in KZN, by default, already you know when you are in that space that these are the languages that are prominent in that province and should maybe find an expression in terms of the implementation. I'm not deviating completely from it. I think if you still feel that we need to debate it further, but what I should say, colleagues, in terms of us moving forward, the work that we are doing here today, it's not final. There's still a task team that is going to collate all the input that we are sort of bringing up today in terms of whether we are moving for 2 or we are advocating for 7 in terms of the number of official languages. And then the task team will deal with that, and then at some point produce a document that will guide in terms of how they dealt with all the input that was brought here today. I think, colleagues, for me, the debate and the discussions doesn't end here today, because I am avoiding a situation where, Prof, we might move towards saying voting. That should not be the direction that we are taking. If the majority of us are saying that let's stick to what is in the Constitution, that should be the final input that will be submitted to the task team that will take this work further. I think, colleagues, if we move along those lines, at least we'll move with a clear direction. Prof, I'm not sure if you would still like to raise something based on that.
No. I think you have responded, but just to say, I think when a matter is being deliberated on, I think we must then, it does not need to get to a vote. We just saw, I think Mr. Tongwan has just told us that we just saw what a vote can do. We need to make sure that input that you're talking about, we have then, it came from the floor to say, this is the resolution under this thing that was discussed. From this, in as much as it's going to, we're still going to go for provincial, municipal, and other consultative processes. But from this Lokotla that met, what was the resolution that came out when that point was discussed? So that we don't leave it open-ended.
Okay.
Yeah, it might not be the final input that goes into the act, but we would then know that when we met here, this is what we have resolved. Thank you.
So you want us to conclude on the numbers before we move to the second point, if I got you correctly. I recognize Prof. Rahuhu, Mr. Tohwane, and you will be our number 4. Let's hear Prof. Rahuhu.
Thank you, Chairperson. Look, we are here because of compliance-related issues. So the Act cannot supersede the Constitution, Chairperson and colleagues. I know this is an emotive issue, but I think at some point we should be able to remove our personal feelings and emotions so that we remain objective and we do justice to the project. The Constitution is the supreme law of the country. And I mean, the Act should be consistent with the Constitution. And the Constitution is clear to say national departments should communicate, should use at least 2 languages. And there are reasons why those 2 languages were postulated, because those who understand language policy and planning, I mean, a leading scholar of language planning, Joshua Fishman, when he defines language planning, he says language planning is all about the authoritative and allocation of resources. You can't plan a language if you don't have the resources. You need a budget to implement whatever language policy. So there are reasons why 2 languages were mentioned in the Constitution. So it will be injustice for this Act to be inconsistent with the Constitution. And colleagues are right. I mean, those departments that can afford to operate in more than 2 official languages, there's nothing wrong with that, because they would have complied with the Act, they would have complied with the Constitution. So that is my ideological stance, Chairperson, to say we should align this Act with the Constitution.
All right.
Thank you.
Mr. Tohwane, is it still on this point?
To react, yes, it is still on this point. Thank you very much, Chair. In response to the point that was made, to say maybe the variations can be introduced to accommodate local, provincial, and national. That point then becomes null and void as soon as we take care of what the Constitution stipulates, which is 2 at minimum, or at least. I think the historical consumption of the education is also contributing to the misunderstanding of at least. At least does not mean 2 max. It means that's where we start. But at least, and I'm using it again. So when we move from local, we go up. Maybe we will end up with 7. And then we go nation, maybe we'll end up with 12. But we cannot be in contravention of the Constitution. And it was well calculated, to be honest, when they said at least 2. Because that's where everybody will start. And then all these languages will be accommodated at the end of the day. So let us not feel bad to say at least 2. The implementers or the evaluators, and we did talk about who's supposed to be the body of, that is supposed to be monitoring the implementation. The monitoring team will be bestowed with the responsibility to check whether the 2 complies with the demographic nature of the population that they serve or not. And that should be our mandate moving forward. Thank you, Chair.
All right, thank you. Before I hand over to you, sir, I just want to establish whether it's still on this point, because I want us to move us towards concluding it, because if it's you are adding to what has already been said, it looks like we are moving towards saying, let's stick to what it's in the Constitution as the final input that should find in its expression in the Act. I'm not sure, sir, were you still going to add on that point, or it's a different dimension that you want to bring into the table? Over to you.
Thank you, Chair. I'm not sure how to answer that question up until I say
You can
one.
raise your point.
Thank you. Thank you. Chair, the chairperson of Commission 1 and my Leonard colleague mentioned that when we embarked on this exercise as the Commission, we did not only look at the Constitution. We looked at the Constitution, we looked at the Act itself, we looked at the amendments, and we looked at the case law. So we didn't only rely only on one piece of legislation. Now, I would like to throw the spanner into the works and refer the House to the case law as we are debating this issue. Can we kindly, as far as I am aware, unless I'm corrected, the Lawrence matter did not go to the Constitutional Court, meaning the Lawrence matter at the Supreme Court of Appeal remains authority. The judge in the matter, I would like to direct the House to read paragraph 11 and 12 of the Supreme Court of Appeal opinion expressing themselves on this matter. If anybody in the House has the judgment, can we please go to paragraph 11 and 12? Maybe, Chairperson, it will give some direction on the issue. Thank you.
Dr. Khalani, you want to provide some insight into the judgment?
No. I don't have a copy. I would really gladly do so. What I want to point, there was an advert on TV, and then the people were saying, I want to thank my producer, and I want to thank my manager. And then the woman walked in and said, what are you doing, guys? They said, we're forming a band. And yet they were giving award speeches before they could even have a band and the music. So we're confusing the final product and process here. When I raised the question of policies, the Constitution says at least two. You can't debate it. So the debate on that is moot. Right? We can't debate that. But government must provide policies in all official languages. Government must provide. How you choose to, it's your situation and the context and so on. But you've got work to do before you choose to. You need to have translated all your policies into all official languages so that when you want to use to, they're readily available. So now what we're doing here, we're thanking the producer and the manager, but we have not done the translation. The Department of Sports, Arts and Culture has got terminology lists. which all departments present here must access and show due diligence in that regard. I have just been reliably informed that all the terminology for all government departments, for all our policies, have gone through all the verification and authentication processes. Now, I was moving to the point that says, therefore, let us move forward with regard to the quota of policies within each government department that would need to have been translated within a given point in time. You can't debate the fact that the Constitution says at least 2. That's a given. Any debate there, it's moot. But you need to agree on the percentage of your policies that you are towards the advancement of human rights and freedoms, that you translate towards the advancement of that. So that when you go to a point of wanting to achieve equality by, we're going to Northwest, it's Setswana and maybe English. That's a once you've got them translated, you simply choose from the policies that you go then. When are you going to translate and make those policies available? If you focus on 2, 3, 2, 3, 2, 3. The idea is not 2 or 3. The Constitution says 2. But there's a process. If this was a meeting and not an amendment consultation process, yes, I would move towards resolution. Okay. But this is not a resolution process. We are making submissions that can we start first by ensuring, one, that all government departments at least have language policies in terms of this act. That these language policies, too, that they are available in all official languages. That's number 2. How you use 2, it's as and when the people are accessing service that you then deal with it. Thank you.
Okay. Colleagues, I think we need to move now. I'm looking at the time. We have a presentation that needs to be handled by our colleagues from legal, starting from 12:30. I think we have spent much time debating on the question of the numbers, and it looks like in terms of the submission that needs to go to resolve the issues of the numbers. The move is saying, let's stick to the 2 that are prescribed or pronounced in terms of the Constitution, so that we don't find ourselves contradicting the supreme law of the country. But how we go about doing it, it's another process, colleagues, that we cannot really vote on because we are not taking resolutions here. We are just making submissions that still needs to be considered at another level. But the final outcome, all of us colleagues will still have an opportunity to input on it and voice our disagreement or maybe whatever issues that we might need to raise, colleagues, in terms of how we move along in terms of incremental implementation or of multilingualisms based on our circumstances. Colleagues, I would like to propose that we move on this one because I think we have spent so much time on it. We have had different arguments in terms of how we should sort of reflect on it. And it's a food for thought for all of us, colleagues. The debate doesn't end here. It should continue in our little corners. We are just a fraction of the sector as we sit here. We still need to consult further with people who are part of our sector, and maybe they will give us more insight in terms of how we should proceed. And I think one issue, colleagues, that came very strongly when I was listening to the commissions that I would like maybe us to also consider. The issue of the role clarification between PANSALP and DSEC. And when I listened to most of the reports of the commissions, it was in terms of the monitoring part of it. Who monitors what and at what level? And I think it's very important, colleagues, that at least when we do the final submission that we are going to make, we also consider it in terms of how is it going to be presented, in terms of the final input that will be consulted further with the public. Any views on that? Mr. Nemutavuni, you are noted.
Application of Act in the amendment here. So there is this section 3, 1A(c), wherein you are saying the submissions regarding compliance must be sent to National Language Unit or PANSALP. So this causes confusion because, I mean, are these institutions or these departments have to choose where to send their compliance reports? So who will consolidate and what will happen? How about if 3 sent to arts and culture and then majority sent to PANSALP? So I think that has to be clarified, not to use or. So the submissions must be sent to one institution. Yeah, and then if there is a need, that institution, after consolidation of the reports, can share the entire report with another institution. Thank you.
Okay. Any other input on this one? Role clarification? Prof. Madonsela?
Thank you, Chair. The issue here is, apart from the delegations of authority, the minister is the accounting officer in terms of language matters and is the one who accounts in Parliament. A PANSALP is actually regarded as a Chapter 9, or like a Chapter 9 institution that should even be monitoring the ministry that the minister is leading. So now, under the current situation, you are then expecting a funder to be the one, the funded, to be the one that actually exposes if there are any challenges from the funder, which becomes a problem. I think here it is the issue of knowing exactly when do we say PANSALP is responsible, and especially even in a case where the powers seem to be limited, therefore, in terms of the monitoring itself. So now, the issue of separating these two would give us should I say, a way forward in terms of PANSALP being given the authority and the power that it should have in terms of the Act to monitor even the ministry itself than what is happening here. So it is important to clarify those roles because we are where we are now solely because of the very same powers that seem to be taken away from PANSALP. But on the other hand, as much as we know that the accounting officer can delegate responsibilities, but the accountability therefore remains with the accounting officer. Thank you.
Okay, thank you, Prof. Any other taker on this one? submission that maybe we should consider the fact that PANSALP should be given more powers in terms of monitoring the work that is done in terms of the implementation of this act. It's something that colleagues you feel we should consider adding as part of our submission. There is a hand, but it's proper. Yes.
Thank you, Chairperson. My understanding is that from a constitutional implementation point of view, PANSALP is still considered a Chapter 1 institution, not a Chapter 9 institution. And there's a reason why PANSALP was considered a Chapter 1 institution. So if you are a Chapter 1 institution, but you want to play the oversight role, you become a player and a referee at the same time, because in terms of the Constitution, when you check Section 6 of the Constitution, you check all those roles that the Constitution is talking about. There's nothing that talks about the oversight role. So if the PANSALP Act empowers PANSALP to provide the oversight role, at some point we need to be clarified as to how do they link that act with the Constitution, because the Constitution is not saying anything about the oversight role. And the current, the act, the bill under attention talks about entities. So if PANSALP is an entity, meaning PANSALP should also implement the act. So you can't implement the act and play the oversight role at the same time. And when you check the Chapter 9 institutions, there is one, you look at the CRL Commission, right? So my question is, what should be the role of the Chapter 9 institution when it comes to the oversight role? Because you can't play the oversight role if you don't have the autonomy. And at the moment, PANSALP doesn't have the autonomy because its autonomy is limited, because it's being funded by DSAC. The very same DSAC is expected to submit its report to PANSALP. So where is the objectivity there? So I think if we can get some sort of a clarification as to what should be the role of the relevant Chapter 9 institution when it comes to the issue of non-compliant, we should be able to achieve something. Thank you, Chairperson.
Okay. While you are still on the floor, Prof. Rahugo, I want you to help us to move on this one in terms of how do we reflect it in the submission that we are making. Do we reflect it as more clarification is needed in terms of what should be the role of a Chapter 9 institution vis-a-vis the role of PANSALP, as you clearly indicated at the beginning that according to you, PANSALP is not listed as a Chapter 9 institution?
No, it's not. It's a Chapter 1 institution.
So we should make the submission to that effect, that that role should be clarified.
Yeah, but the Constitution is clear to say the mandate of PANSALP is to develop and promote and create conditions for these languages. That is the fundamental mandate of the Pan-South African Language Board, is to develop. And from that mandate, we need another structure, we need another stakeholder to monitor PANSALP if PANSALP is delivering its constitutional mandate.
Okay.
Because if PANSALP is failing in its responsibilities, we need to be told, we need another body to give us that information.
Okay.
Thank you.
I think you have made your point clear. Mr. Tohwane, are you still on this point? Because I want us to move towards
Yes.
summarizing the discussion so that we give our colleagues who are going to take us through the what you call the roadmap enough time to
Yes.
present whatever
Yes.
they are presenting.
No, I wanted to assist you in regard to, with regard to how you should put it or coin it.
Okay.
It should be a conflict of interest. It should be raised as a concern, as a conflict of interest in terms of the monitoring. And therefore, the proposal is that there should be a structure that should be delegated, which is not conflicted, to deal with monitoring of the implementation of the Act.
Okay. Colleagues, we have had a good discussion in terms of how we would see the Act moving in terms of the amendment, and the various commissions have presented and made their recommendations or proposals, which at some point, colleagues, were sort of clarified. And I think we should now conclude here with an understanding that this is work in progress, that we couldn't really conclude here today. Consultation is ongoing, and the proposals and the recommendations that were put forward will be are taken into consideration, and they will be put forward to the task team that will take over from here. But what came up very clearly, colleagues, it's the issue of the numbers in terms of the languages that we rather consider maybe sticking to what the Constitution is saying in terms of the numbers, so that we don't find ourselves in contravention with the Constitution as the supreme law of the country. And issues of role clarification as the point that we were on now. It's another point that colleagues, I think they came out very strongly on in the various commissions to say it needs to be clarified more so that it doesn't cause some confusion come the time when the implementation of the Act comes into effect. I think this is what it's going to be presented, colleagues, to the task team moving forward. And it's a process, colleagues, that it's not going to be concluded today. Hence, we need colleagues from legal to sort of do a short presentation in terms of the roadmap, the legislative process that it's going to be followed after all the input has been consolidated. Like I indicated earlier on, colleagues, all of us will still have an opportunity to interact with the input. We are not in a meeting where we need to vote and take resolutions as we are constituted here today. I would like to thank you for allowing me to facilitate the discussion. Very interesting issues were raised, which to my thinking, colleagues, will not fall on deaf ears. And I think we are moving towards the right direction, colleagues, in terms of how we would like us to progress as a country. Where? Right at the back. I'm told that there's a hand at the back, and my apologies, I didn't recognize the hand. And my apologies if Mr. Tang, please just be brief, sir.
Not me, stop trying.
Sorry, Chair, this
Oh,
is,
it's not you, it's the lady seated next to you, my chairperson.
I've,
Okay.
I've given up the hand because it was a historic hand. So I'm just going to add maybe something that we didn't discuss.
Okay.
But it was framed in the first meeting we had on the very first day, the issue of sign language and how it's going to be implemented as the very last official languages that the language that has been added. In the opening, it was mentioned that there will be strict enforcement to make provision for people who use sign language, right? And we've also made a lot of comments on that. And we received feedback that, and we discussed maybe the emphasis on it every time is because they want to ensure that provision is made, even though it is a very small percentage of people, right? So I think that is also one of the things that we need to look at when we propose this bill. Yeah, and when the advocates speak again, like in the beginning, there was a framing of 7 languages, sign language. Maybe he can also just explain the reasons for that can of worms that was opened.
Okay. If I recall very well, in the new additions that are proposed, especially with regard to South African Sign Language, there was a point where there was some sort of inconsistency in terms of how it should be treated. Instances where it was saying accommodate, other instances it will say implement. I think there's one commission that, I can't remember exactly whether it was Commission 1 or 2, that put it very clearly during their presentation, colleagues, that sign language is already an official language. It should be implemented on par with all official languages. We cannot, at this point in time, be still talking about accommodating. We should be moving towards fully implementing the language. And thank you, Chairperson, for raising it. I think it's a valid point that it should reflect very strongly in the act implemented or to be treated in equal footing with any other official language in terms of capacitating people who will work in that language and make sure that everything that we do in terms of implementation, sign language is also part of that. Thank you for bringing that up. I think it's very important that you raised it right at the end, otherwise we should have lost sight of it. Colleagues, I'm inviting Mayor Muntle Khapula to come upstage to take us through the roadmap. Colleagues, my colleague here is saying that we are all provided with a hard copy of the presentation that she's going to do in terms of the roadmap. So she's not going to project it on the screen. The intention is that we should follow on our hard copies as she presents. And my understanding, it's not going to be a very long presentation because it's more about the roadmap. Where do we go from here? Thank you very much. Over to you.
Thank you, Mr. Munisi. Good afternoon, everyone. Colleagues, my role here today is to indicate to the members who assisted us with the public consultation about a way forward, on the roadmap. One may ask, what is a roadmap? I'm going to deal with a roadmap on the high level of legislation. A roadmap in terms of a high level legislation is a strategic visual planning tool that outlines the journey from a current state to a desired future legislative or policy outcome. As from today, colleagues, the 4 commissions has given their views. From here, there will be a technical committee led by legal. The purpose of that committee will be to consolidate the comments, the one that we did from March. Remember, today is our 5th day here. We had 2 days in March. Unfortunately, we didn't finalize our comments. So that committee will start from consolidating those comments in March until today. After consolidating them, we'll review them and inspect them and do a final draft. That draft, we will submit it to the Department of Justice. The reason for us to submit it there under the Office of the Chief State Law Advisors is that for the state law advisors to ensure that our draft complies with the Constitution. As you know, that Section 2 of the Constitution provides that every law inconsistent with the Constitution is invalid. So we want to make sure that our law complies with the supreme law of the Republic. And indeed, if it complies with the Constitution, the Office of the State Law Advisor will issue the opinion or the certificate as a proof that indeed the Department of Sport, Arts and Culture has complied. After obtaining the certificate from Oxley, we must have another certificate, which is called a sailor's certificate. This one, we will get it from the presidency. After that, there will be a lot of administration involve the minister. The minister will this lot of administration, it will go to Parliament where the draft will be presented before the different clusters, in Parliament. Those clusters will need the draft together with those 2 certificates, and also the proof that we as the department, we have done public consultation. That is why when we enter there, we request you to register. Colleagues, have you all registered since Wednesday, Thursday, Friday? If not so, please, colleagues, we beg you, before you leave these premises, go and register, because this register will be needed in Parliament. And thank you in advance, colleagues. Colleagues, as I already said, that there will be a lot of administration in Parliament. There will be a submission signed by the Minister informing the Speaker of the National Assembly about the presentation of our draft bill, and also the chairperson of the National Council of Provinces, requesting them to table this draft before the Parliament. There will be a debate in Parliament. Then after that debate, if all houses of the Parliament are happy with the process, then they will ask the President to sign this draft into law. However, President has discretion. He may say our bill does not comply with the Constitution. He may approach the Constitutional Court if he considers that we didn't comply with the provisions of the Constitution. However, if the President is happy, he will sign a bill into law. As soon as the President signs that bill, we will see it with a big capital letter A. That shows that now is legally binding. And after that, it will be gazetted so that everyone can know that now this particular act has been signed into law. And then there will be also a date indicating when will that act start to be binding to all the citizens. I thank you all.
Before you leave the stage, are you prepared to take one or two questions of clarity? Because I see already there's a hand from Mr. Ntakambi, maybe, and two from my colleague over there. Can we hand over a mic to Mr. Ntakambi? Are there any more hands, colleagues? Because I've only recognized those two. I would like us to move towards closure because after Mayor has responded to those points of clarity, the next item is where I'm going to call Ms. Ndima to come and do the vote of thanks and closure. Over to you, sir.
Thank you, Chair. Just like my twin sister, I also resisted. I didn't want to say anything, but I'm compelled, just for clarity. I would like to be given the comfort that the process that you have just alluded to was not a predetermined process. Why I'm saying that, if you listened to the recommendations that have been made, they are now touching on something that says the deliberations, now that we are talking about the three spheres of government, we must also involve the provincial government, we must also involve the local government sphere. Now, listening to the process, when are you planning to involve the provincial government and the local government spheres into the crafting or making inputs in this amendment bill? So that we get clarity. Are you, even though maybe they may not be afforded this chance like national we were afforded, Are you going to take it through that whole process? By the time it comes to them, it has already gone through what you have explained there. I just needed clarity that where do you involve them? Because it seems as if it is a very, very key recommendation that this cannot, if it affects provincial and local government level, they also need to be consulted. Thank you, Chair.
If I may answer him and then, thank you.
If we give to Mr. Nhlakana's worship, okay, let me give him the opportunity. Your mind is not on.
Thank you, Chair. Ntate Nhlakana has taken much of what I wanted to say. Chair, with the process that I just had now, we might have opened a litigation for us. Other institutions who are not part of this process might challenge the amendment before it goes anywhere. There is a process where, in fact, I wanted to advise the department to publish this amendment to the whole Republic for the people to make their comments. And each and every single comment must be looked at, whether it enhances or it does not enhance the amendment. After the team has looked into each comment, they then consolidate and send it to the Office of the Chief State Law Advisor for Constitutionality. The three spheres of government will then again be given opportunity to participate in that, including other organizations that are not having an opportunity to sit as we are sitting right now. So I needed to also, Chair, to give that advice that this must be published to the Republic for them to make their inputs. And the task team to look at those inputs, consolidate, and then the amendment will be taken to the Oxla for constitutionality. Otherwise, this amendment will run into courts and will never see light of day. The court take their own time. And we might take 3, 4, 5 years dealing with the amendment, defending the process at the court of law. Thank you, Chair.
Thank you, Mr. Tima. You can respond.
In combination of both. Thank you, Chair. I will combine the two questions. My colleague, we would like to say thank you for your great comment. As legal, our purpose, yes, indeed, is to avoid litigation. We'll indeed try to avoid such because it will cost the department a lot of money. And with regard to when will the other spheres of government be consulted, my colleague, I'm from legal services. As a legal expert, we act on instruction. Upon that, the technical teams, the client will advise us where and when. At this moment, it's difficult for legal services to say tomorrow or the following day. I'm not sure if I answered your question, my colleague.
I see Mr. Nhlakana's hand. Are you happy, Mr. Nhlakana? Yeah, maybe in closing.
Program Director.
Yes.
I'm not going to say I'm happy, but I read and understand the situation that we are putting the legal colleague under. So recognizing the position that we are putting her under, let the sleeping dogs lie.
Okay. I think you can leave the stage. Okay. Yeah. Yeah. Thank you, colleagues. I'm not going to waste more time. I think, Mr. Ntlakana, your point has been taken note of and it will be attended to. I would like to invite Ms. Ndima to come upstage and give us a vote of thanks and officially close this session, colleagues. On my part, I'm no longer going to come upstage. I would like to thank you, colleagues. We have had a very fruitful discussion. We will leave this room today with more knowledge and expertise in terms of how we approach implementing multilingualism in the country. Thank you. Over to you.
Thank you, Mr. Minister. Thank you, Mr. Minister. Colleagues, I know that I'm the last person between you and lunch, but I won't take much of your time. But I just want to say from the bottom of the department's heart, we really thank you. I cannot say this person and that person, but the sector, as we are all here, would like to thank you so much from the legal team, from the departments, from the universities that are here, from the entities, especially I saw that we've got maybe 2 representatives from the entities. I know that we are lacking in that part, but we appreciate it. And whilst I'm thanking you all also to apologize with the up and downs that we had, cancelling, postponing, but you are still here from March 10 to 11. You were dedicated as you are today. And from the 5 changing to the 6 to the 8, you are still here as with this effort, trying to make sure that our act, because it's not the Department of Arts and Culture's act, it's our act that will be implemented by us for the input that we have given, that we have provided as the sector. We heard and we listened, and I'm hoping that our legal services, and as they are working with other stakeholders, they've taken note, and all the proposals that were made, we are aware and we listened. And as the extensions that were proposed, we thank you for that, and that will be considered by the task team that is going to be formed to look at all our proposals, because it cannot be the department, because as I indicated, it's not our work, but we will be involving experts that will be assisting the department. And as for the processes, as legal services has explained, we will be taking the bill through all those proposals that have been made. And after we think that we've implemented and also included all the proposals that were made here, then the processes, the parliamentary processes will begin. And I'm hoping that the stakeholders that are not here, as I'm mentioning, I won't dwell much to the issue of who are those stakeholders. Is it going to provinces, local? That will be decided by the task team. But it is going to, there is a process in that, the roadmap that I saw, it is going to go for public comments so that we give the public an opportunity to comment on the bill and make their own submissions. And even amongst us, when we were consulting with legal services, they said as much as you are here, maybe individually when you are at home going through the documents again, you will still want to make a submission. So we thank you for that, that you will be still submitting whatever submission that you think we forgot this. So now I'm thinking, so colleagues, I cannot thank you enough for everything that we have done for this bill. As with all the changes in government, the processes, I'm not saying it won't be approved, but budgetary constraints are a key here. So we are hoping that it will still be acceptable. So we are still together through all the processes. If there are urgent matters that need our feedback, we'll come back again and say, hey, sector, this is the challenge. Can we come together? Maybe the feedback, you can even get the feedback during the National Stakeholder Engagement Forum of where we are. But for now, I just wanted to say thank you, and thank you for our monitoring body that has been with us. I know that's the main debate here, but they've support and guiding us on the compliance issues. They are not here today, but represented by our Chief Director. We thank you, all of you, for supporting this process, because legal services are very clear, as Mehapula is begging that please sign, because that's the document that is going to take them to Parliament. And if they are shortfall in the consultations, they might be in trouble with Parliament. So colleagues, with those few words, I'm saying thank you, and lunch will be served. And colleagues, lunch is served, and until we meet again, thank you. And it is downstairs. Thank you.
I don't know if you can come and